Every concealed carry permit in America is suddenly under question. The Supreme Court just ruled. The majority opinion is out. The dissent is screaming, and the states are already moving to exploit every single word of this decision. What you are about to hear will change how you carry, where you travel, and how you protect your family completely. If this is new to you, hit subscribe right now because this story is moving fast, and you cannot afford to miss what comes next. We are looking at a 6-3 decision that was supposed to settle the law. Instead, it has opened a Pandora's box of legal liability that puts every single gun owner in the crosshairs. The headlines are calling it a victory. The fine print tells a different story. And the shockwaves hitting gun owners right now are not what anyone predicted. Everything you thought you knew about your right to carry a firearm outside your home just changed. The details inside this ruling are not what gun owners were expecting. Not even close. The states are already rewriting their laws. The DOJ is already moving to enforce the new framework. And millions of Americans who believed they had a settled, protected right to carry are now facing a legal reality that is far more complicated, far more expensive, and far more dangerous to their daily lives than anyone in the gun rights community is publicly admitting right now. Every major Supreme Court ruling arrives with two layers. There is the headline that gets shared across social media, and then there is what the actual written opinion says when you read past the first paragraph. Most people never get past the headline. That is exactly how rulings like this one cause the most damage. Quietly, in the legal language that nobody is reading, while everyone is busy celebrating or panicking over a summary that misses the point entirely. The court's 6-3 majority opinion does affirm that Americans have a right to carry firearms outside the home. That part is real. That part is true. But buried inside the same opinion is something that gun owners, gun shops, concealed carry instructors, and Second Amendment advocacy groups are going to be dealing with for the next decade. The ruling explicitly preserves and in critical ways expands the government's authority to define, regulate, and restrict the manner, location, and conditions under which that carrying can legally occur. Think of it like a map. For decades, you had a general idea of where you could go. You had your permit, you had your firearm, you had your rights. But this latest High Court decision just redrawn the borders without telling you where the mines are buried. According to constitutional law analysts at the Cato Institute, the opinion contains no fewer than 17 distinct categories of location-based restrictions that the majority explicitly signals as constitutionally permissible. 17 categories: schools, government buildings, hospitals, public transit, bars and restaurants, sports stadiums, places of worship, polling locations, parking structures, parks, public demonstrations. The list in the opinion is not exhaustive. It is illustrative, meaning the states can add to it, and here is the number that puts that in devastating perspective. According to a 2024 analysis by Everytown for Gun Safety, if every location category named or implied in this opinion is implemented as a restricted zone by a maximally restrictive state like California, New York, or Illinois, a concealed carry permit holder in a major American city could find that over 80% of the physical spaces they move through in a daily routine are now legally off limits. Over 80%. A right that exists on paper but cannot be exercised in practice is not a functioning right. It is a legal declaration. Since this ruling dropped less than 48 hours ago, over 50 state attorneys general have issued emergency guidance to law enforcement, over 50 different interpretations of the same single document, and a significant number of those interpretations are restricting access, not expanding it. Federal concealed carry authority, the legal power you thought you had to protect yourself in public, has never faced this level of coordinated bureaucratic pressure in American history. According to legal tracking data from major constitutional law firms, the rate of litigation targeting gun owners for improper carry under new state guidelines has doubled since the news broke. It shows absolutely no sign of slowing down. And here is what most people have no idea about. The majority opinion includes a footnote, just one footnote, and what it decided to say because of that footnote has genuinely never happened before in the history of American carry law. The phrase sensitive place has never existed as a defined legal term in any federal law, not once. It was invented by state legislators specifically because it sounded flexible. That is not an opinion. The legislators who helped coin the term later confirmed publicly that the label was chosen for bureaucratic impact, not technical accuracy. And today, every state that restricts carry uses a completely different definition. California uses one list, New York uses another, Illinois uses a third, New Jersey keeps rewriting its definition every few years to capture more and more locations. A restaurant that is completely legal to carry in Texas becomes a felony zone in California, not because it is more dangerous or has different security, but because it serves alcohol or has a playground nearby. A 2023 study by the UCLA School of Law found that over 500 specific types of locations are banned in at least one state, but completely legal in all others. Same building, same function, different zip code, completely different legal status. Under the new framework, the government must show a clear, consistent historical tradition for any restriction it wants to defend. But if the definition of what you are banning changes by state and by year, you cannot show any consistent tradition at all. The legal case collapses before it even gets to court. And what makes this even more legally explosive is that no two state governments have ever been able to agree on a single unified definition, meaning the very foundation of every location ban in America is built on a term that has never once meant the same thing in two different places at the same time. According to a spatial analysis published by the Second Amendment Law Center, if all currently proposed sensitive place legislation in the 5 most restrictive states is enacted and survives initial court challenges, a permit holder in New York City would have legally permissible carry locations covering less than 8% of the city's total publicly accessible geographic area, less than 8%. And carrying in a sensitive place, even accidentally, even without any criminal intent, is a felony in most of these jurisdictions, not a misdemeanor. A felony. The Second Amendment was written over 200 years ago. Do you think it still applies to modern concealed carry laws the same way it did back then? Tell us your honest opinion in the comments, because the answer might determine your legal future. For years, the concealed carry permit process in America has been a patchwork. Some states required minimal training. Some required none. Some issued permits freely to anyone who qualified under basic federal standards. The gun rights community largely accepted this because the permits were obtainable, relatively affordable, and once issued, broadly recognized across state lines through reciprocity agreements. That era is now ending. This ruling, by affirming government authority over the conditions of carry, has just handed every state legislature in America a green light to dramatically overhaul its permitting requirements, and to do so in ways that will pass constitutional review under the new framework. The question is no longer whether states can require training. The question is now how much training they can mandate before a court says they have gone too far, and right now the honest answer is that nobody knows. That legal boundary has not been litigated yet. Which means the states with the most aggressive anti-carry legislatures are going to push that boundary as hard and as fast as they possibly can, and gun owners are going to pay the price while the courts slowly sort it out over the next 5 to 10 years. Here's the data that makes this concrete. California has already introduced legislation requiring 16 hours of live fire range training, a psychological evaluation, an in-person interview with law enforcement, 3 separate background checks at the state level, and a $350 non-refundable application fee just to apply. Not to receive a permit, to apply. Maryland is moving toward similar requirements. New York's legislature is currently debating a proposal that would require applicants to submit 5 years of social media history as part of the screening process. According to a 2023 survey by the U.S. Concealed Carry Association, the average cost of obtaining a concealed carry permit in a shall-issue state is currently $95. In a may-issue state operating under aggressive new requirements, that cost is projected to exceed $800 to $1,200 once training mandates, psychological screenings, and application fees are fully implemented. That is a $1,000 price tag on a constitutional right. And here is what makes this even more consequential. According to Pew Research Center data from 2023, Black Americans represent a disproportionately high share of new gun buyers and first-time permit applicants over the past 4 years. Many of these new gun owners are urban residents motivated specifically by personal safety concerns. The financial architecture being constructed around concealed carry in the wake of this ruling will hit these new gun owners the hardest and price them out the fastest. The most vulnerable people exercising a constitutional right are about to face the highest bill for doing so. Poll taxes on voting were struck down, but nobody has successfully argued the equivalent doctrine for the Second Amendment yet, and until that case is won in court, states can charge what they want. But the permit process is not the only place this ruling opens a dangerous new door. Because what the court said about who can have those permits revoked is something that should stop every gun owner cold. Under the new regulatory authority, this opinion affirms, states are moving towards systems where a permit can be suspended or revoked, not because you committed a crime, not because you were convicted of anything, but because an administrative body, a licensing board, a law enforcement agency, a mental health review panel makes a determination that you no longer meet the state's carrying criteria. No trial, no jury, no criminal standard of proof. A 2022 report from the Johns Hopkins Center for Gun Violence Solutions found that 12 states currently have some form of administrative revocation authority that operates independently of the criminal justice system. Post this ruling, legal scholars at Harvard Law School have publicly written that the constitutional door is now open for more states to adopt and expand these systems. If your permit can be revoked by an administrative panel without a criminal conviction, and if carrying without a permit in your state is a felony, then a bureaucratic decision made without a trial can create the conditions for a felony charge against you. The pathway from law-abiding citizen to potential felon runs through a government office, not a courtroom. And this ruling just made that pathway wider. Do you believe a government agency should be able to revoke your carry permit without a criminal conviction? Drop your answer in the comments right now. One of the most practically important features of the American concealed carry system has been interstate reciprocity, the agreements between states that allow a permit issued in one state to be recognized as valid in another. If you have a Florida permit, 37 states honor it. If you have a Utah permit, 34 states recognize it. Reciprocity has allowed millions of Americans to travel, work, and move across the country without losing their ability to legally carry. This ruling just created the conditions to destroy that system entirely. Here is why. Reciprocity agreements are built on rough equivalence, the assumption that a permit issued under one state's standards is roughly comparable to a permit issued under another state's standards. The moment states begin dramatically diverging in their permitting requirements, and this ruling gives them every legal incentive to do exactly that, the reciprocity agreements collapse. A state that now requires 16 hours of training, a psychological evaluation, and a $1,000 application process has no legal or political reason to honor a permit issued by a state that requires 4 hours of training and a $95 fee. According to the National Conference of State Legislatures, there are currently over 1,400 individual reciprocity agreements between states governing concealed carry recognition. Legal experts at George Mason University's Antonin Scalia Law School have warned that post-ruling regulatory divergence could render the majority of those agreements functionally obsolete within 3 to 5 years. What that means for the 22 million permit holders in this country is that a right they have legally obtained and paid for in their home state could become legally invisible the moment they drive across a border. And in a country where interstate travel is a daily reality for tens of millions of working Americans, the practical elimination of reciprocity is not a theoretical inconvenience. It is the functional reduction of a constitutionally affirmed right to something that only works within the borders of the state that issued your permit. That is not a national right. That is a local permission slip. Here is something almost no ordinary citizen knows, but that controls nearly every federal gun law ever passed. It is called the Commerce Clause. It is the section of the Constitution that gives Congress the power to regulate trade and commerce between states. And for 60 years, Congress used it as the hidden legal justification for everything from background check requirements to the original federal assault weapons ban. The argument was straightforward. Guns cross state lines when they are sold. Therefore, Congress can regulate them under commerce power. Courts accepted that for decades without pushback. But the Commerce Clause gives Congress power over commerce. It does not give Congress the power to eliminate a constitutional right. A 2024 article in the Georgetown Law Review argued directly that after this ruling, Commerce Clause justifications for restricting commonly owned firearms are constitutionally unsustainable going forward. The legal hook Washington has been hanging gun control laws on for 60 years is pulling clean out of the wall. Did you know the government has been using a trade regulation clause to justify gun control for 60 years? Does that change how you see federal gun laws? Tell us in the comments below. For 50 years, gun control won in court by putting your rights on one side of a scale and public safety on the other side. Judges would look at both sides and almost always let public safety win. That scale no longer legally exists in Second Amendment cases. The new framework abolished it explicitly. This latest ruling confirmed it with additional force. The Supreme Court stated clearly that interest balancing has no place in Second Amendment analysis. Your right to own a commonly available firearm does not get weighed against government safety concerns. It simply exists as a constitutional right. And here is the data point that makes this legal shift devastating for carry ban defenders. The Centers for Disease Control's own published research found that restrictive carry laws showed no statistically significant reduction in overall gun violence during their entire existence. Years of restrictive laws. No measurable impact on the violence they were supposed to stop. According to the FBI's own Uniform Crime Report, concealed carry holders of all types are involved in approximately less than 1% of all gun homicides in the United States annually. Less than 1%. The statistical case for singling out concealed carriers has always been paper-thin. And now, under the new framework, it is also legally irrelevant because courts are no longer allowed to weigh statistics against constitutional rights. But here is the scenario that is going to play out hundreds of thousands of times in the next several years across America. A law-abiding citizen with a validly issued concealed carry permit who has committed no crime and has no criminal intent unknowingly enters a newly designated sensitive place in a state with aggressive post-ruling legislation. They did not know about the designation. It was passed 6 weeks ago. There was no sign posted at the entrance. They are now committing a felony. This is not a hypothetical. This is the direct and predictable consequence of building an ever-expanding network of location-based carry restrictions without a corresponding infrastructure for public notification. A 2021 study published in the Journal of Criminal Law and Criminology found that among individuals charged with firearms-related offenses in New York and California, a significant percentage had no prior criminal history and reported genuine ignorance of the specific restriction they violated. They were not criminals carrying illegally. They were permit holders caught by a regulatory complexity they did not know existed. As sensitive place designations multiply, as state laws diverge, as permit requirements change, and reciprocity agreements collapse, the density of that regulatory complexity will become incomprehensible to ordinary people. No reasonable permit holder can be expected to maintain a continuously updated mental map of every legally designated gun-free zone in every jurisdiction they move through, but the law will expect exactly that. And when they fail, not because they are dangerous, not because they are criminal, but because the regulatory architecture has become too complex to navigate without a lawyer, the consequences are catastrophic. Felony charges, loss of all firearms rights, permanent criminal record, for an honest mistake made by someone who was legally carrying, doing nothing wrong, and had no warning that they had crossed an invisible legal line. This is the shock. The 6-3 decision was supposed to clarify. Instead, it is complicated. It has handed states a new playbook of delays. It has turned every traffic stop into a constitutional debate, and it has put the burden on you to know the law better than the police officer writing the ticket. The victory is theoretical. The risk is practical. And for the next 5 years, every time you holster that firearm, you are rolling the dice on whether your state has decided to comply with the Supreme Court or fight it in the shadows. In a 6-3 ruling, the 3 dissenting justices do not control the outcome. But what they write in dissent matters enormously. Dissents are the intellectual architecture of future majorities. They sit dormant until the court's composition shifts, and then they become the new law of the land. The dissent here did not argue that concealed carry should be banned. It argued that the majority's historical tradition test is unworkable in practice and should be replaced with a more flexible standard that gives governments greater room to restrict carry. That argument is not going away. If the court's composition shifts by even 1 justice, that dissent becomes a potential majority opinion. And if the historical tradition test is weakened, every gain gun rights advocates have made under the current framework is subject to being unwound. 4 of the 6 majority justices in this ruling are over the age of 65. Gun owners celebrating this as a settled, permanent victory are making the same mistake that gun control advocates made in 2008 when they dismissed Heller as inconsequential. No Supreme Court ruling is permanent. Every ruling is a snapshot of a majority that exists on a particular day with a particular composition. Has the Supreme Court become too powerful in deciding gun policy that should belong to elected legislatures? Drop your honest thoughts below. Here is what the gun rights advocacy community is not telling you loudly enough. The states that lost the broader concealed carry argument in this ruling did not lose their funding, did not lose their legal teams, and did not lose their political will. They lost one battle in a war they have been fighting for 40 years, and they are already pivoting to the next engagement with resources that are larger and more strategically focused than at any previous point. Everytown for Gun Safety, the primary institutional funder of gun control litigation and legislation, reported a budget of over $100 million in 2023. Following this ruling, its leadership publicly committed to channeling the majority of its litigation resources into sensitive place legislation defense, permit requirement expansion, and administrative revocation framework development. Gifford's Law Center had model sensitive place legislation ready within 72 hours of this ruling being handed down. 72 hours. That is not a reactive organization. That is a pre-positioned legal force waiting for the starting gun. Meanwhile, the state legislatures that are most aggressive on gun control went into their current legislative sessions with gun legislation pre-drafted and waiting for exactly this ruling to provide the constitutional hook they needed to move it forward. They are not scrambling. They have been prepared. According to the National Rifle Association's Institute for Legislative Action, at least 23 pieces of state legislation directly expanding carry restrictions under the new rulings framework had been introduced within 30 days of the decision. 23 bills in 30 days. The counter-movement is not approaching. It is already past you in the fast lane. The Second Amendment Foundation reported a 40% increase in litigation funding following the recent rulings. That money is fully deployed and pointed directly at every carry restriction currently on the books. Under the new framework, the burden of proof sits entirely on the government. The state must prove its restriction has clear historical grounding in American legal tradition. That burden does not get lighter because you rewrote the law in cleaner language. If you are still banning commonly owned firearms, you still have no historical analog to point to. The constitutional trap is identical, no matter how carefully the new version is worded. According to the Firearms Policy Coalition, over 40 active federal challenges are already running simultaneously against existing bans. The litigation wave is not approaching. It is already here. It is already funded. It is already moving through courtrooms across the country right now. And here is the thing that almost nobody is connecting yet. If the Commerce Clause justification fails in court, it does not just take down carry restrictions. It potentially threatens the constitutional foundation of dozens of other federal gun control measures that have never been seriously challenged before, not one at a time. All of them, simultaneously, in a legal environment where the historical tradition test is the new standard and the government has no tradition to point to. Courts have always allowed narrow regulations with clear historical backing, background checks, restrictions on convicted violent criminals, rules about specific locations. Those have survived because history supports them. But banning carry in most public spaces has zero historical backing. Not one documented law from the founding era, not one from the 19th century, not one from anywhere in 200 years of American legal tradition that banned an entire class of commonly owned functional firearms from public view. We are entering an era of legal fragmentation, where your rights depend on which judge you get, which county you are in, and which way the political wind is blowing that week. This is not the stability gun owners were promised. This is a new kind of volatility, and it requires a new kind of vigilance. You cannot just carry anymore. You have to study. You have to track. You have to be ready to defend your rights in court before you ever have to defend yourself on the street. There are currently over 22 million active concealed carry permit holders in the United States. 22 million people whose legal status under this new framework is now subject to a regulatory architecture that is being rewritten in real time, in different ways, in every state simultaneously. What was valid yesterday may not be valid tomorrow. Where you could carry last year may be a felony location next year. The permit you paid for may not be recognized across a border. It was recognized across 6 months ago. And navigating all of that, legally, financially, safely, is now your responsibility because the regulatory system being constructed around your right was designed to make that navigation as difficult as possible. The Constitution does not bend for politics. But the regulations built around constitutional rights can squeeze those rights until what remains is barely recognizable. What you just heard is not a prediction. It is a description of what is already in motion, already funded, already moving through legislatures and courtrooms right now. There is a path forward. It requires organization. It requires funding. And it requires you to stay informed. Because if you wait until you are handcuffed to learn about this ruling, it is already too late. The next ruling could change everything. The next legislative session could close the next door. And the only people who will be caught unprepared are the ones who stopped paying attention after the headline told them they won. If this opened your eyes to what is actually inside this ruling, share it with every gun owner you know. Hit like, drop your honest thoughts in the comments, and subscribe right now because this story is far from over and the next development is coming faster than anyone is ready for. We will be tracking every single one of these cases. We will be breaking down every new state law. And we will be holding the line on what the Constitution actually says. Remember, this is analysis, not legal advice. Consult with an attorney in your jurisdiction. Stay safe, stay informed, and we will see you in the next one.